Okay, it's 12:01. Should we go ahead and get started? Okay. Welcome to today's New Mexico Family Advocacy Program Echo Session. Instead of our usual practice or practitioner issue processing sessions that we do.
Oh, that's really cool. That's really cool.
Today we'll have a special presentation, and we are super happy to have Special Master Catherine Begaye with us. And the session is not going to be limited to program attorneys, social workers, and parent mentors as usual. We hope that this will still be an opportunity for open discussion and for us to learn from our presenter and from each other. I am Catherine Brock. I am one of the lead social workers for the New Mexico Family Advocacy Program, and I will be facilitating today. If we could have the other leads introduce themselves.
I'm Andrea Gunderson. I'm one of the lead attorneys for the program.
I'm Leslie Jones. I'm one of the lead attorneys for the program.
Hi, Camille Hancock, lead social worker for the program.
I'm Quiva Hubbard, parent mentor coordinator for the program.
And we have Jen Vieira, who's going to be offering tech support for us. Jen, did you want to add anything?
It's the same stuff, you know, if you join by phone, please mute by pressing *6 to mute and unmute or interact with the group. Same way when you're, by video, please remember to mute and unmute yourself as you interact with the session.
Thank you. And then also, so that we know that who is with us today, if you could please enter your name and email in the chat. And also please remember to do our post-session feedback. Our funding for our professional learning through New Mexico Family Advocacy, ECHO, comes from a federal grant. So these surveys are very important to the program's broader evaluation and continued funding. And we will put that in the chat, right, Jen? The link for that?
Chat.
Okay.
Yeah, I'll be adding it a few times.
Perfect. So our workshop today is ICWA Courts and Cultural Competency with the Indian Child Welfare Act. Our workshop, again, as I mentioned earlier, today is going to be presented by Ms. Catherine Begaye. Catherine Begaye is a special master and is currently a hearing officer with the 2nd Judicial District Children's Court, where she has played a major role in the development of and will be presiding over a special Indian Child Welfare Act division of the court. Before being a special master, Catherine, as a licensed attorney, had been in private practice since graduating from the University of New Mexico School of Law in 2004. She discovered her calling in the abuse and neglect arena and has been involved with this area of law since 2013. She has represented parents and children all around the state, particularly in Indian country. She believes strongly in New Mexico families, including Indian families entitled to ICWA protections. She also serves on the Children's Court Rules Committee. Our learning objectives today, we're hoping that you will learn about the recognition of cultural needs that led to the creation of ICWA and the ICWA Court, learn about ways in which the ICWA Court will be different than Children's Court, learn questions to ask in order to avoid making assumptions about the cultures of Native American families, and gain insight into the need for cultural competency in order to better represent Native American clients, whether in the ICWA Court or in Children's Court and other judicial districts. Before I pass this on to Special Master Begaye, we would want to remind everyone that if you have any questions for Ms. Begaye, to please keep them the subject matter in general. Please do not ask any questions related to specific cases or clients, as she's unable to answer any questions about any matter. And I'm going to turn it over to Ms. Catherine Begaye.
Thank you very much, Catherine. So I do want to start by saying that I'm always really happy when Leslie thinks of me when it comes to ICWA stuff and when it comes to ICWA Court. And I feel like a lot of people still have that same sort of thought of, I know the person that I'm going to ask this question of, and it's Catherine Begaye. I really love my new position and I want to be able to keep it. So I'm not going to be able to give you that legal advice in the way that I could when I was in private practice. And so my bosses, the people that I work for now, is the court. And so while you may have lots of really great questions about what is the process, what is the next step, what am I supposed to do when confronted with this issue, If it's a legal one, if it's related to how you should present your case or the defenses you have, I'm just really not going to be able to answer that. But that doesn't mean that there aren't people in this chat, and certainly attorneys in ICWA Court who have some expertise in this area, that I would ask you to reach out to. So everybody understanding that, for sure, I definitely want to jump right in. So as Catherine said, there are 4 learning objectives that I want to cover today. The first 2, I imagine, is going to be me talking to you a lot about the history of ICWA, and then also how Bernalillo County came to have their own ICWA court, and then how we see them being different. I do want to have questions from you, but my guess is they won't really come until the 3rd or 4th area of this. So when you have them, put them in the chat. And then I see them when they pop up, but it would be really great, maybe Catherine or Leslie, if you could redirect me if I'm in the middle of my presentation, if you see one that is really helpful, okay? So I know when I'm looking around this room, this virtual room, I see a number of attorneys, I see social workers, I see former justices, I see former colleagues of mine, people working with AOC. We all come from very different backgrounds, current judges as well. And I think that I'm really happy to look out in a room like this and see that there are so many people interested in this area. We live in New Mexico, which has a fairly large population of Native American people. And it might be surprising, but 10% of our population in the state is Native American people, even though on the nationwide scale, Native people make up less than 1%. So I tell you that because more than likely, no matter which jurisdiction you're in, whether it's Bernalillo County, Gallup, or Hobbs, Las Cruces, you are going to find yourself possibly representing a Native American parent, child, youth, or even the department in a case like this. And so I think it's really important that you all have that sort of background to understand why the law was created and also how the law should be implemented. I'm not here to advocate for one position or another, or how I think the law should change or how I think it shouldn't. It's really just to give you that background. So ICWA itself, the actual law itself, was born out of the need to remediate, to change some federal policies that separated Indian children from their parents. We spend a lot of time, I think, in undergrad classes and sometimes in law school and Indian law classes, talking about that federal history that brought us to the point of all of the changes that have been happening in Indian country. What I want you all to keep in mind is that all of these things, while they are technically in the past, are really still recent events for Native people. And so I'm going to put together, I want you to sort of understand that timeline so that it puts in perspective some of that information. If I can have everybody mute yourself, that would be really helpful. Okay. So the Indian Child Welfare Act was created in 1978. I don't know how old you are, but I was 2 years old at the time. That would have been within my lifetime that this law came into effect, which means that it was remediating things that came right before that. That period of the collision of Indian people and new people coming to the United States really led to some different philosophies about who owns this land and what does it mean and how does it look when they own land, all the way down through, are these people who live in this different way than most Western people do, does this look like they actually are instilling appropriate values in their children? Are these children who are going to be successful? Are these children who are going to go out into the world and be able to be self-sufficient? And I think there was a lot of judgment around looking at a different group of people and deciding these people don't match up with my values. It doesn't sound like they're saying the same thing. They live in a very different way. They don't look like they are kept up. And so it really led to two different worlds obviously colliding. And so there was a lot of policy throughout history of the United States to have have Native children raised outside of their community for their own benefit. It would be better if this kid was raised in an Anglo family or a non-Native family so that they can take advantage of an education, they can learn the English language, they can be successful, they can go on and get a higher education, they can do something different than the possibilities that are open to them if they were raised in their home community. That led to removal of children from their homes, either by sending them to boarding schools, so they lived separate from their parents. It led to other policies when that wasn't working. It led to other policies of assimilation. So moving Native people into communities where they would be able to take advantage of a trade. This is something that my own family experienced. My mother was part of this assimilation relocation when she was 16 years old. She was offered this really fantastic opportunity to finish up her high school in Cleveland and then go on to a professional secretary school so that she could then be instrumental in making her own way in this world and making sure that she set herself up so that it was a different life than she came from. And so for me and my family, this is still very recent when we talk about that assimilation sort of process. The hope, of course, was that Native kids would grow up and that they would be able to speak the English language, they would be successful, they would have kids that are successful, but that came at the sacrifice of lots of tribes' cultures, their language, their way of life. And so it really put a dent in the identity of Native people as it sat right there at the brink of 1978. So this law was put in place, as I said, to remediate some of those federal policies from the past, to make it different so that going forward from that point, we were not redoing, we were not endorsing, we were not recreating the same situation that was present before. So with that law in place, the goal was to allow Native people to raise their own children with supports from people like CYFD, CPS agencies, to really have a respect for the fact that that Native people have their own way of thinking, they have their own value structure, they have their own support systems. There is value in being a Native person and knowing your culture and knowing your language, and to really strengthen that tribe. So one of the things that I think is a key difference that isn't always accessible or understandable by people who work in this area of law is that when we're working with non-Indian families, non-ICWA cases, the interests that the court has to always look out for are the interests of the child and the interest of the parents. Those are always what we're doing. That's why we have respondent attorneys representing parents. It's why we have guardian ad litems representing children. And these are the arguments that we hear in court all the time, right? The battle between what's in the best interest of the child versus the protection of the constitutional rights of the parents. And so you all know this every day because this is what we do. But when ICWA came into place, it was protecting another interest that I think is sometimes inaccessible or not understandable. It also requires the courts who are hearing these cases, and by extension, the parties for the case, to understand that there is a separate interest, sometimes aside from the parent, sometimes aside from the child, that also has to be protected, and that's the rights of the tribes to their own self-identity, to the strength of their own tribes, to that separate tribal identity. One of the reasons why the law feels so inaccessible sometimes, and I can see it happening even with my colleagues, with colleagues that I had before, members of the bar, and even in the people who work on these cases, part of the reason why it feels so inaccessible is we don't have this broad education on what it means to practice in the area of Indian law, or to work with a separate sovereign, to understand that this separate sovereign has their own system of government, they have their own value system. And so that recognition of another sovereign having just as much information and accessibility and care for this child, I think is sometimes really hard to understand. As an attorney, we get it. We get it when the country of France has something, involved with the United States, or when states have disagreements with one another, state of Arizona, state of New Mexico. But there aren't as many examples when it comes to tribal law related to state action. This is one of those cases. This is one of those areas where it does. And so the expectation that a permanency planning worker or even ICWA workers on the tribal side would understand what this means, that two sovereigns are trying to work out these issues between themselves and to protect the rights of the child, is, I think, a hard thing for them to understand, which means that it's really on the attorneys to provide that education to your clients. If we know that permanency planning workers and ICWA workers who themselves have been trained in what we do here, trained in the law concerning children and reunification and all of the policies we put in place under the Abuse and Neglect Act, if they are having a hard time accessing it, it's even more removed than that parents and children would not have that same set of language. They don't understand the benchmarks. And so it's really important that we take the time to explain that to our clients, whether you are representing the child or a youth or a parent. That's true of any case that you're in, right? Non-Indian or an Indian case, ICWA or a non-ICWA case. But it's especially important that you have that understanding when you are working with Indian families. So one of the things that I think there is a struggle over is this sort of idea that, well, if I don't understand what it really means and nobody's telling me that I'm doing it wrong, I'm just going to keep doing all of my cases the same way. If I'm a permanency planning worker, I know the goal is to work on reunification, and that means that there has to be a treatment plan in place. And these are the items I'm going to put on the treatment plan because that's what we do for all the other Indian families. That's what we do for all families. Why should it be different? Or I don't understand how it's going to be different for Indian families. That is the place where the department should be working with their client to help make that transition or understanding, to really be involved in tailoring a treatment plan that is really going to work at providing the remedial services and rehabilitative programs to prevent the breakup of the Indian family. But that also requires respondent attorneys and guardian ad litems and youth attorneys to understand what the law is so that they know when it's not being followed. And so a lot of times, especially if you did not go to law school here in New Mexico for sure, or if you didn't ever really think you were going to work on Indian law, it is hard to understand ICWA. And I think we can all acknowledge a lot of people in this screen are social workers, people who have a sociology background, people who work in the area of law, and judges as well. I think we can all acknowledge that sometimes there are value judgments that overlay some of the decisions that we as advocates make, or we as judges make, or we as people working directly with the families make about how certain services should be implemented, or is this really going to benefit them? And recognizing that sometimes those values, those value judgments are there, I think is a really important consideration in being able to then understand where the changes can be made within your own practice. And of course, I think if a person is only handling one ICWA case a year, or maybe two at the most, when they are thinking about the CLEs they're going to get, or the educational credits they're going to get for social work, maybe that doesn't rank high on the list, but it doesn't mean that the law isn't there. That doesn't mean that the law doesn't exist. It means that we have to educate ourselves on the law. So I guess I want you to know that whole background, because it's really important to understand that that was part of the reason why in the second judicial district, we wanted to build up an ICWA court. This actually, from my perspective, from where I sit, was a convergence of two different ideas. The first is that we had already internally within the courthouse understood that we had a really high number of ICWA cases, but we didn't know which cases they were. We couldn't identify them right off the bat. We didn't know the state of those cases, meaning were they determined to be ICWA cases and then there's no question, nobody needs to go back and do any cleanup on it? Or are they cases where the question of whether or not this child is actually an Indian child is still hanging out there and the parties need guidance? The second thing is we knew that we had them, but we didn't know the numbers. So identifying which cases the parties were identifying as ICWA gave us a starting point, but it also allowed us then to really finalize what those numbers were. Finalizing that number was really critical to us understanding where we were within all of New Mexico and understanding, are we working with most of the New Mexico's Indian children in the Department's legal custody? Or is there somebody out there, another jurisdiction out there that is actually handling more and maybe we can learn from them? So we went through that process. The other thing that, that maybe the judges who are on this call and the people from AOC will understand is when you pull up the electronic version of the case in Odyssey, there was nothing there that would tell you this is an ICWA case. There was nothing there that would alert you there should be an ICWA worker that should be called for this case. There was nothing that was alerting the court that, oh, this is an ICWA case. I have to remember these are the laws that apply when you open the case for your docket that day. And so we thought we really could help ourselves by figuring out the numbers that we had, the types of cases that we had. Was there a particular community that we were working with? Are the outcomes for these kids different than non-ICWA cases? Meaning, are they staying in custody longer? Are they being TPR'd at a different rate? Are they actually getting guardianships in a different way? And so it really allowed a self-examination. So when we went through that entire process, this started towards the end of 2018, the beginning of early 2019, and it ended at the end of, it started at the end of 2018 and started at the end of 2018 and ended near the beginning of 2019. So about February, just right into March is when the final report was written. And we came up with some numbers that we found to be really eye-opening. And maybe this wasn't eye-opening for parties who were working for the department because, they have all of the cases versus a respondent attorney or a guardian ad litem who only has some. So we looked at all the cases that were pending December 31st, 2018. Of those cases, we found that 105 of all of the pending cases, which was about 500 at the time, 105 of those cases had mentioned ICWA, had an ICWA notice in them, that there was a finding at some permanency or pre-permanency or judicial review hearing or mentioned at custody that there may be something about ICWA. But none of those decisions appear to be carried throughout the course of the case. So there may have been some mention at the custody hearing. There may have been an ICWA notice filed, but there was nothing followed up at adjudication or after that. And sometimes that finding changed from hearing to hearing, which was really both surprising and frustrating because it meant that the court was not keeping on top of what the right law was that needed to apply to this case. So about 20% of our cases, 500 of the 500, 20% of our cases mentioned ICWA in some way. We were able to go through and look at every single one of those cases and determined that 63 of 500 cases could be immediately judicially determined to be ICWA cases. So we knew at that moment, 63 cases are definitely ICWA. There was another group out there, not surprising. I think it was between 11 to 15 cases where the determination wasn't really clear, because there had been a mention early on, then it had gone away, and then it had reappeared, and then it had gone away. Sometimes there was an ICWA worker there. Sometimes there were questions about who was supposed to be present. And so there was no consistency. And so what we wanted to do was to provide clarity for the parties, provide clarity for the tribe, provide clarity for everybody, including the court, that these are the cases where that law applies. The other thing that we discovered in doing that review of the cases is that we were working with let me see, 15 different tribes, some of which were not inside New Mexico. But of those 63 cases, we discovered that 43 cases were with the Navajo Nation. That, I think, we had a suspicion about that, but it really surprised us that we had 43 cases with Navajo families all across our 3 judges, and there was not any consistency about how we were handling them or how the court was interacting with the tribe. So we discovered that if ICWA court were to open on that day, on the day that this study was completed, we would be working with 90 Indian children and 97 Indian children's parents. And that really hit home for us. That's 100 people, 100 children who are depending on the court to get it right, either for reunification or for a TPR or for permanent guardianship. It was really critical for us to get it right for these children. And it also made us understand that the court's working relationship with the Navajo tribe needed to be much stronger than it was. We needed to have a consistent practice with them. The procedural posture of a lot of those cases, of the 67 cases that we had, the majority were pre-TPR. So the department was still working on reunification or some sort of guardianship with these families. There was only one case that was mid-TPR, and then there were only a small handful. There were only 15 cases, 15, that were post-TPR. So we didn't know what that meant. We didn't know if that meant children were being TPR'd and then quickly adopted and then moved out of the system, or were these 15 cases where these kids were just aging out within the system. So we did a closer look at that. We felt much better about knowing which ones our ICWA cases were and having that really solid determination. But what that led us to do is to have a conversation among the judges to say, well, now that we have these numbers, we can't just turn a blind eye and say, okay, we'll do this reassessment at 10 years from now again. So we wanted to do a couple of different things. One, we wanted to put a policy or procedure in place so that we did not have to do a look at 500 cases again 10 years from now. We wanted to put a system in place so that we could get new cases that were filed, that immediate review, and put orders in place so the parties could follow it, so that we could get a determination on the Indian Child Welfare Act for all of the parties. The second thing that we did is we thought, is there a way for us to pull together these cases in a way that we knew when we woke up on this morning that the cases we were going to hear that morning were all going to be ICWA cases. It put us in that frame of mind. It helped alert us to the fact that that was going to happen. We could set up parameters around the inclusion of tribes at these hearings. Parties would understand how important it was to the court that we knew that these were ICWA cases. And then the third thing is that was right around the time, I think it was November of 2018, that one of the judges from Colorado had come down and she had given us a presentation. She had let us know that they had the number 6 ICWA court in Colorado to really help handle their cases, to make sure that they funneled through the system appropriately, that they were giving it the due care that it needed, and to really focus on those requirements not only the legal requirements, but also to include community service providers. So people who are providing services to Native American families or Native American focused programs for children, to like really pull them together in one central place to help wrap around these families. And so she challenged us, her name is Catherine Delgado. She challenged us to consider that with the information that we had the potential to sustain a court here. And so that's what we did. We spent a year from the beginning of 2019 all the way to December of 2019, putting in place the structure. We had several meetings about how that was going to be created, the goals that we wanted to seek, the data that we wanted to track, the people that we wanted to have involved, the alternative ways of dispute resolution, the values that this group was going to have when we went into creating an ICWA court. And so at the end of that was sort of our centerpiece. We had the training, which was really getting everybody, not only participants in our state system, but also the ICWA workers, social workers, providers, to really understand that Bernalillo County was going to do something different here, and it was important to us to have that community support. So our intention was to open the doors January 1st, 2020, which we did, even though it was a weekend, I think. We opened it right after the first of the year. We had, I think, our ICWA court retreat, either February, I think it was February of that year, where we were setting the stage for everybody, letting them know this is what we're going to do, this is how it's going to work. These are some areas that are not quite settled yet, so we need to build out some of those things, but really to impress upon everybody that this is the groundwork, and from what we are doing, we're going to build an ICWA court to make it strong, and to really use the advice and the support of the attorneys that were in the program, the community providers, as well as the ICWA workers. One of our biggest and best support systems for this is the department. They created an entire ICWA unit to work with these families. I think it's 5 permanency planning workers plus a supervisor, and then they created 2, I think, attorney positions to handle these cases. And so having that partnership in place is really fantastic. Then COVID hit, which really changed the goals that we could actually implement for ICWA court. So I'm going to tell you what our goal is. I'm going to tell you how ICWA court is different than children's court or regular cases in the children's court system. But I have to tell you that a lot of these things cannot be implemented right now because of the Supreme Court order about what cases the court can hear and who can be involved at the courthouse, the procedures that are in place, the limited, what are they called? They're called reopening plans. So they have to be approved by the Supreme Court, and right now everything is very limited to, I think, only custody hearings, permanency hearings, TPRs, and adjudications. So that puts us in a bind of not being able to implement ICWA court in the way that we wanted to. But I actually want to use this as an opportunity to sort of build on some of the goals that we started, and maybe in the meantime set this up so that when the doors actually are open, whether that's 2020 or 2021, we'll be ready. So on the legal front, for the practitioners, for the attorneys for the cases, there is a close and strict adherence to the Indian Child Welfare Act. Practitioners are expected to have the legal knowledge and to know how to use and argue ICWA issues. This includes the BIA regulations, the BIA guidelines. This includes the provisions of the Children's Code in New Mexico. It also includes a lot of the case law. And so we want to have some training on that to make that knowledge more solid, because once the attorneys are trained, they can then turn around and work with their clients about that. One of the things that's unique to Albuquerque in particular around this, but not around the state, is that the attorneys that are assigned, that the attorneys that are a part of ICWA Court can be assigned to have different roles. So in our jurisdiction, that for some reason has always been separated. There's been the youth attorney, the guardian ad litems, there's been the respondent attorney pool, and they haven't always crossed. But in our court, in our ICWA court, we do have them cross so that they are allowed to represent as a respondent attorney or a youth attorney or a guardian ad litem. And we did that intentionally. We really think that it would help the practitioners, especially when it comes to the Indian Child Welfare Act, understand the ICWA arguments, understand the ICWA protections, understand the cultural needs of the family, to understand the value system, to understand working with tribes when they had to do it from a different point of view each time. As someone who practiced around the state, especially in Indian country, when I was sometimes the guardian ad litem, the youth attorney, or the respondent attorney, it gave me completely different insight into how the department worked with me or communicated with me, or how the tribes communicated with me, or even the weight that the court gave my argument depending on which position I sat in. And so I thought, so one of the things that the court thinks is really important is having attorneys have that well-rounded experience when they are in ICWA court. So we have the training program for the nuts and bolts of ICWA. The other thing is that we wanted to provide options or alternatives for other ways to resolve the disputes. So traditionally, we have mediation in children's court. I think the code says you have to have a pre-adjudication conference or a pre-permanency conference. We've sometimes been able to massage that into a mediation, but for ICWA court, there is the ability to do peace circles or talking circles, and also to include a wider group of people who can provide support for the families when they are working through the system. So sometimes in tribal communities, that is the aunt or that is the uncle figure. And having those people at the table to really sort of reinforce that community support is important to us. And so we really allow a lot of that to happen. Of course, the intentional inclusion of tribes at the front end of cases and throughout the entire case. We did a training with the Casey Family Programs last year where the different ICWA courts and the people who were thinking about building an ICWA court came together in Denver. I think it was maybe even a year ago now. And they talked about the fact that when tribes are involved at the front end of cases, when they are involved in that very first hearing, provided that voice, children spend 100 days less in custody because the tribe has been involved with the problem solving, helping to hammer out some of those issues. And so we really took that to heart. We want to make sure that the department is including the tribes in the decisions that they're making, letting them know this is where we plan to go. This is our approach to this case. What are your thoughts on that? And a lot of times those conversations should happen outside of the courtroom, right? Like you get to consult with the people that you want to and your experts. But importantly, the expectation is that the respondent attorneys and the GALs and youth attorneys, when appropriate, would also seek that same sort of discussion with the ICWA worker. Not everybody has to be on the same page. You know, not everybody has to have the same goal. That oftentimes is not, that's not a reasonable expectation when we are working with families in abuse and neglect cases, but that doesn't mean that those communications with the tribe shouldn't be happening. So tribes are non-parties for the most part, unless they move to intervene. And so we support the tribe's intervention when they want to be, but even when they're not, they are still their position is taken into consideration. Some of the ways that we do that is intentionally calendaring around tribal holidays. So this is something that you can take away for your own practice, which is if you have a case that is an ICWA court case, you can solicit from the tribal worker, is there a time when your Pueblo is closed or when you know that you're having a tribal holiday? The Navajo Nation has a sovereignty day that we celebrate in the same way that people celebrate the 4th of July. For us, that is an important holiday. We take it off, we make that celebration of our independent status. And so Other tribes have that same sort of thing. So planning around that is an easy thing, right? Like how many other days of the year can we set this ICWA case? We can plan around their one holiday. We also do the same thing with making sure to include them on pleadings that are put out by the court. We make sure that at the bottom that we say this is also going to the tribal representatives, so they are kept informed. While the department has their independent obligation, we also want to say that we are providing that information to them in case for some reason that isn't happening from the department end. Placement preferences is one of the highest priorities in ICWA court. We currently have 8 families on the program. I think that there are 3 that are potentially wanting to come in, and there is 1 that could be coming in to ICWA court within the next week or 2. So we're at 8 cases, and from the last staffing, I understood that we had 100% placement with relatives, the highest placement preference. That doesn't come from me saying, the law says you need to follow this placement preference. That comes from the department internally changing how they're approaching families and really trying to find the most appropriate placement with families, which I think is really fantastic. It's probably the best evidence that I can shout about that the department's way of approaching these cases has changed. That doesn't mean that there isn't a need for foster families and for other foster families who are non-native or non-preferential to work with these families, but the goal is to have that highest placement preference. We also really want to encourage that any meetings that are happening outside of the courthouse with all of the attorneys for the case also include the tribe at the table. So that means getting them on the telephone, asking for their position. It doesn't mean telling them, here's the court report 5 minutes before the hearing and expecting them to read it right there. The other thing is that we are setting judicial reviews and permanency hearings by scheduling order and scheduling them every 3 months. So I was telling you earlier, we really wanted to alert ourselves when we had ICWA cases on the docket. And so all of these cases in ICWA court are consolidated onto one day. They're going to be the second Tuesday of the month, which allows tribes to keep in mind, this is my ICWA court day, which allows us potentially to set Navajo Nation cases all on that one day to really help the parties really keep in mind all of those protections for Indian families and for tribes. The expectation is that there are going to be arguments on ICWA throughout a case. So if there's a deviation from placement preferences, an attorney would raise that. We also had one of the things that I thought was going to be really fantastic, and maybe if we get out of COVID, we can actually do it, was to allow our attorneys and the people who are participating with us, the permanency planning worker, ICWA workers, to do a tribal visit around the state. We had so many tribes who wanted us to come and to visit their homeland and to see what their government structure was like and to celebrate with them some of their events when they have them. And because of COVID, tribes are shut down, so we're not able to go to them, but we also want to be very safe, right? So we are practicing that social distancing. So a lot of that is not able to happen right now. But we want to really solidify that relationship between tribes and the court and these attorneys so that we really get the best out of everyone. We also wanted to have reunification celebrations for these families when they're reunified, sort of in the same way that you normally would when it's somebody's birthday or when some big event happens, somebody comes home. Those celebrations happen, and we sort of wanted to recreate that for Indian families. I think oftentimes attorneys will sign off on the order saying, you know, this case is dismissed, all of the causes and conditions have been alleviated, and that, well, that's satisfying for an attorney, right? You get to close out your case, you're done, family has moved on, you get to pick up your next case. We should extend the same care to Native families and putting them back together, and so we want to have a celebration about that. So I guess I just want you to have that sort of understanding so I could move into the next part, which is not making assumptions about Native families, about their culture, and really how to interact. Leslie, I think it's 12:45. How much time would you like for me to spend on this portion? Or Catherine?
So we have until 1:15, so
Okay.
it's really take the time that you feel is needed.
So I'm going to go ahead and talk a little bit about this because I think this is probably the most, the one thing you can take away and really be able to use day to day. But certainly I'm willing to answer some questions maybe when we get to the end of it, wherever seems most appropriate. So one of the things that I don't know if it's common knowledge, but I'll share it with you. Sometimes the word Indian can hit people, Native people, the wrong way. It's sort of, I think it causes some people to think, I'm not an Indian, you don't know who I am, those people are from across. It puts up this barrier without even being able, before you've even gotten through your introduction of, hello, I'm your attorney, you know, it sort of sets people the wrong way. But while it's an outdated and an inaccurate reference to the people that we're working with, it is a legal term of art. It is a word that we have to use when we are practicing in children's court. I don't think there needs to be a change to the language and how we use it, but it needs to be something that we are all familiar with saying. We need to be comfortable talking about Indian children, Indian child's tribe. We need to be able to say those words without sort of that baggage of what it means or if I might be offending someone, which is where I think you can take away by having a conversation with your client to say, the very first hearing you're going to have in front of the court, one of the first questions the court is going to be trying to figure out is whether or not your child is an Indian child and the name of your Indian tribe. I think if you don't know that that is going to be the expectation at that first hearing, it can just set the wrong tone for how things are going to go in that first court setting. When you think you're going to be respected by coming before the court and they're going to try to work with reunification and work with your family, and then all of a sudden this word that can sometimes feel a little derogatory can be used in court talking about you and your family, I just think it sets the wrong tone. So I think you can spend a lot of time explaining why that's a really important consideration, why we need to have these questions asked, why it's important to make that identification, but also to let the family know that once we make that identification, then we're going to start using your tribe's name. So while I am an Indian person by definition, right? I'm still a Navajo person. That's how I identify myself. That's when I think of my identity, that's who I think of. And I think your clients have that same sort of feeling. So once you get past the conversation about this is what you're going to hear in court and these are the reasons why, I think you can help them sort of get used to that by learning their tribal affiliation and learning what kind of relationship they have to the tribe. So in the Indian Child Welfare Act, we talk a lot about membership or eligibility for membership. Those are technical terms and technical words. But what your client will often use is, I'm enrolled, I'm eligible for enrollment. It's up to you to be able to parse that language. And there are several pueblos in New Mexico and probably more tribes across the United States who use a different sort of valuation. Sometimes it's related to blood quantum. Sometimes it's related to, can you trace your heritage back to these other people who were on this original list? Sometimes it's even, you are not eligible for membership, but you are a descendant of our tribe. So there's lots of different words that are used to describe a person's relationship to their tribe. Once you learn that, I would encourage you to not stop there, to not say, okay, she has told me that she is a descendant of a Sleta Pueblo. I don't know what that means. You have a natural resource in these cases for you to ask that question of, and that's the ICWA worker. call them and say, what I have to assess is membership. What does it mean for someone to be a descendant of your tribe? What does it mean? Does that mean that this person can eventually be enrolled? How much can they participate in the cultural activities of the tribe? From the attorney perspective, you are trying to figure out whether or not you fit in this box. Is this person enrolled or eligible for enrollment? But that doesn't mean that the cultural history, the cultural importance, the values that your client is going to have attached to this case and their family isn't going to be colored by some of that relationship to their tribe. So knowing what that is and then getting some more definition around that is really important. The other thing that I would encourage you to do is to find out what would be required to get the child enrolled in the tribe. So in the state of New Mexico, we do something that is not required by the Indian Child Welfare Act, but required by our statute. And that's that if the department has legal custody of a child, the law tells them that they need to work on getting them enrolled. That seems very paternalistic for a group of people that we are trying not to be paternalistic about, right? Like it should be the decision of the family and the tribe and the parents about whether or not this particular tribe is the one that they want to enroll with, or if they're eligible for two different ones, who is going to make that decision and that determination. So I think having that conversation with your client, whether you represent the child or the parent, will help inform you about whether or not this is something that you need to be pushing, or whether or not it's something that you can say, I think the participants for this case need to be having a conversation around enrollment. It may not necessarily include the attorney, but that conversation needs to start happening. So I think there are also some false presumptions that Native people will always want to have Native American service providers. Our community is really small. And so it's likely that you are likely to run into other people, whether or not you're anticipating it, at some of these service provider locations. And so oftentimes when you have a conversation with your client and you say, I have the perfect place for you, it would be First Nations, they may already have an idea that every one of their family members goes there, or every one of their ex-husband's family members go to that same location to get services. It may not be the most comfortable for them, but that doesn't mean it's not worth exploring if there are other places that they know of. I think when I had clients, a lot of them knew who the Native American service providers were within their community, where you could get healthcare services, where you could access services related directly to your own tribe. I knew my Native clients even knew which AA programs or which NA programs were the ones where they would find the most Native people at. Like they really already knew a lot of these things before they had their conversation with me. And so again, I would ask you to rely on your clients as some of the first experts about some of those informations, but having that perception and an idea that they don't necessarily always want to have a Native service provider. Not everybody was raised on the reservation. I think maybe that's another presumption that we make. Not everybody wants to go back to the traditional way. Not everybody wants to have that for their family moving forward. And what that might mean to different people and different tribes is really important to consider. A lot of times that's related to the religion that the tribe practices. So when you are having that conversation, I think you need to just be very clear that why you're asking the question is because you want to know what kind of counseling might be needed, what kind of therapy might be needed, what kind of services for your child might be needed. Should they be rendered in a culturally appropriate way? And sort of sussing out for your client what that means for them. So one of the most effective ways that I found, and I certainly would love to hear from all of you if you have a different way, is I used to talk to my clients about what are the kind of services that you want for your child to be able to participate in while this case is going on. Refocusing them on the child in the case really allowed us to break down the barrier of me telling them, you're my client because the department thinks that there is something that needs to be corrected with you and your family. It allowed us to refocus back on the child, that what we were looking for is rebuilding a world within which this child could come back to, that was safe, that was healthy, but that took into account who they were and their own cultural identity. Not everybody that you're going to be working with at that first meeting or even your second meeting is going to be able to sit with you and have that conversation. Whether they are Native people or not, there is a lot of animosity at the front end of cases. And why are you talking to me about this? You don't believe me. I know you're on their side. It's, you know, if you're not going to listen to my side, you know, then I can't trust you. There's a lot of that relationship building at the front end of cases. And so this can also be a little bit harder, but I guess I give you the tip to maybe put it in perspective of, you know, we want to make sure that your child has those culturally appropriate services. What are the things that you value? What would be important to you in getting therapy for your child, or counseling services, or even like a daycare or foster care? What are the values that you would want to make sure that we carried through into that? And then you as the attorney can have that conversation with the attorney for the department, and even be able to provide some of that explanation to a guardian ad litem or youth attorney.
Catherine, I'm just going to interrupt just briefly and just remind everyone that it is 12:57, so anyone who needs to log off at 1, I just wanted to give you a heads up. And also, there are a couple questions in the chat.
Okay.
Deborah Gray was asking if the courts will be reassigning any ICWA cases that are currently in, that are in court that are not in ICWA court. Will they be reassigned to ICWA court? And if so, she's got a lot of follow-ups there.
Well, is she asking if the court's going to be taking older cases and moving them into ICWA court?
Yes.
Okay, I see Andrea nodding her head. I think for the most part, that's not going to happen, because the goal of ICWA court is to really work on the front end work of cases and to do a lot of work around families and building that new relationship. If a case is already at the point where it's about to be a termination of parental rights, or a case is an adoption case or a guardianship case where a lot of work has been done at the front end of cases, that does not seem like the right time to move it into ICWA court to say, we're going to try a new approach. That doesn't serve the best interest of the child. That doesn't serve the best interest of the parents for the case. And take into account what might be in the best interest of the tribe as well, or not the best interest of the tribe, but protecting that tribal interest. This is not meant ICWA court is not meant to capture all of the older cases and pull them in. It's meant to include all of the cases starting in 2020 and going forward. We have a system so that people can say, I think this family really could benefit from having, if it's a case older than 2020, to be able to petition the court and the people who are participating in the court to say, I really think this case would work better if we had advocates, if we had permanency planning workers, if we had an ICWA unit, if we had this group, the support system around them. I think they would have a better success. One of the requirements is that the plan for the family be reunification. So our intention is not to go in and, you know, what is the right analogy? Like shake up the checkerboard or the chessboard, you know, with everybody when they have made their methodical plans about where they were getting and demonstrated all of that to the court, and the court endorsed it. The goal is not to do that. The goal is to help the families that are coming into the system now achieve better and different outcomes than what we have seen in the other cases before. So I think there are lots of requests that come to ICWA court for cases to come in that are older. But I think so far, I think all except one have been denied. But it's really about working with the families on the front end of cases. So I hope that answered the question. The goal is not to pull every ICWA case into ICWA court. It's to pull all the new ICWA cases filed in 2020 going forward into one place, and to really standardize that practice.
Sherry
Let me-
Trescott had a question about,
I'm sorry?
Sherry Trescott had a question about using the correct terminology for the names of, so especially you as being Navajo, do you prefer Navajo or Dene, right? Or do we say Okewinge or, right? So
You would blow my mind if you called me Dene. It would mean that you recognize that I call myself Dene. Dene in Navajo means the people. It is our designation for ourselves. If you were to say that, it's a recognition that I have a cultural identity that isn't imposed on me by someone else, but comes from within. It would it would make me feel like I was in the right company in the moment. It would make me feel very proud. I don't expect you to have that same relationship with your clients immediately. I think you need to tell them, we are going to be using the word Indian throughout these proceedings, and you have to be really transparent about that. But then you can also ask them, what would you like for me to refer to you as? Or during the course of this case, we may have to refer to the kids and their tribal relationship. Do you want me to say that they are members of Zuni Pueblo, or should I say that they are Pueblo? I think you will hear a lot of Native American people refer to one another as natives. That's just like a colloquial term. It's just sort of rolls off the tongue, and it's really accepted, Native person to Native person. I think you cannot go wrong. I can't imagine that you could go wrong if you were to refer to your client, the relationships, anything like that. If you were to use the term Native American, that would be the most sort of respectful, and you would be right on in saying that. I don't think you could go wrong with that. But I think if you wanted to build that relationship, then you could dig one step deeper and say, well, tell me about your tribe, tell me about your tribal identity. How do you refer to yourself? I think some of like San Juan Pueblo is a really good example. It was called San Juan because that was the name that was given to them. They took back their own name and said, we no longer want to be called San Juan. We want to be called by our own name, Okewinge. And so they made that change. That's something that they decided on their own. And now it's a term that we use all the time. So at some point this can happen for lots of people, but I think you can help show that support for your client if you refer to them by their tribal identity. The way that they would refer to themselves. So the next thing I think you can do, and this probably goes without saying, but is that you've got to tell your clients that as much as you argue either for or against it as the children's court attorney or the department's the respondent attorney or the attorney for the child, the court is still probably at some point along the way going to order you to participate in services. And so that might mean the judge is telling you that you've got to participate in therapy or family counseling, or participate in having somebody watching, like a parenting coach within the meeting. Having that conversation about it is really important, because you want to then sort of dig down deeper to say, do you want to work with a counselor that would incorporate sort of traditional healing or your traditional values in the sessions that they have with you? Would that make you feel more comfortable with that service provider, or would that make you feel uncomfortable? Would that not be something that you want to have anything to do with? You can also ask the question in a different way. You can say, would you prefer to have a counselor or provider who works primarily with Native American parents? That's getting at sort of the same information, but asking it from a different way, which I think is really helpful. You don't want to say, you're an Indian, do you want some Indian services? Like, that just does not work. And I know none of us would do that, but it's just being able to avoid saying that directly, which is the issue. Lots of times, and I think you may have heard this, but didn't quite even quite understand it on behalf of your clients, but sometimes they'll tell you that there's a traditional healing ceremony or a technique that they really think would help their family. So sometimes they'll say, we need to have a sing, and that will help this situation. You may be sitting there thinking, I don't understand what that means. But again, you have a natural built-in person that you can take your questions to, the ICWA worker, and say, what did they mean by that? You can also say, you know what, I heard what you said, but I want to follow up with the ICWA worker on this. will you sit with me while I call them? Can we make an appointment? Let's draft an email together. Here's how I wrote it. What do you think? That will allow you to take the information that maybe you are not quite, that you don't quite know how to work, and be able to present it to somebody who might be able to provide that information back. There are people within Albuquerque, a place that is completely urban, that provides some of that traditional healing, traditional techniques, some of those traditional healing ceremonies, sweat lodges, you know, all sorts of different ceremonies that they can provide. And so even if that, from a legal perspective, even if that does not mark off one of the boxes towards the goal of reunification, if it helps your client's mental health to get into the right state of mind, it is something that you should pursue. It doesn't mean that it has to be a treatment plan item. You are required to participate in a SING. That's not, doesn't have to be a part of the treatment plan, but if it helps your client wrap their mind around getting to a point of reunification, that would be very important.
Kylie asks if you have any advice on how we can establish a better relationship with the ICWA workers. And I kind of second her statement there, because I've had difficulty myself as well as she has with getting any sort of response, being able to establish communication with the ICWA worker.
Yeah. So I think that's something that I hear all the time, and I have to say, even as a practitioner, that was something that I struggled with too. But I have to keep in mind that this is a person who is answering the requests of all sorts of people across the United States, not just the state of New Mexico, and not just here in Bernalillo County. When I think about my docket and my caseload, I'm just thinking about the cases that were filed in Bernalillo County that are still pending in front of the Children's Court. It doesn't include all of these other cases, but for people who are working for the tribe responding to the ICWA requests, they really are handling requests not only from the 50 tribes, but even internationally. You know, people have kids off base when they are in Japan or in Germany when they are stationed there. There are native children all over the world that they are responding to. I think this is part of the reason why ICWA Court was so important to us, to build that relationship, so that they knew this is the day that we're going to be working on these cases. These are the days when we can work on the staffing. These are the days when we're going to work on these things, and really respect the fact that they have all this other time to work on their other cases. One of the really important and I think critical things that we need to do is just to really remember that they have a lot going on. But that doesn't mean that if you aren't insistent, if you aren't continuing to try or reaching out or saying, I have these ideas about it, that you wouldn't get a response from them. I think sometimes their job devolves into pushing paperwork and trying to keep on top of the requests that are being made from them, tribal identity, tribal relationships. But that isn't really what they were put in place for. Their goal was really to be that resource to the tribe, a resource to the state, and to the worker and to the people working with families, to be able to provide that insight about that. One of the things that we've done with ICWA Court, and even in building up ICWA Court, is to make sure that we included tribes at the table about what works and what does not work. It's my understanding that that conversation happened again between the department and some of the ICWA workers about how that's going to work. I would actually encourage this organization, the FAP program, to invite some of those ICWA workers to the table and say, how can we communicate with you in a way so that we are working toward the same goal? I think there's a lot to be said about actually hearing from them directly in what works and what does not work. So if you need some of that contact information, I am definitely willing to give it to you.
Thank you. I think that's a great idea.
Yay, I'm happy about that. We try to check in with them twice a year to see how things are going. And we've had some really good feedback in doing that because they've been able to tell us, you know, this isn't working, or this is what we've seen happening in California or Minnesota or some other place that we really liked. And we've sometimes been able to incorporate some of that. I think at our last, Ms. Gunderson can vouch for this. I think it was our last ICWA court staffing. One of the ICWA workers from Isleta del Sur was telling us that she was so appreciative of having this group of people who really were following the law, who were taking into account what the tribe wanted to say and including them at the table, because it was not happening in any of their experience with other cases across the nation. And so that one compliment for our team, I think, went a long way to saying, even if we can't, you know, fully stretch our legs as ICWA court because we're dealing with COVID and we can't get all of those pieces in place, how we're behaving and what we're doing, even on video conferencing and on the telephone, is even more than what is normally being given to Native people and Native tribes and ICWA workers. And so we really want to build on that and include them at the table. So I would encourage you to reach out to them and see if maybe you can have a listening session or training session with them. I think they always want to provide that information. Again, there are 530, was it 574 tribes across the nation. Nobody is expecting you to master every single one of those tribes, but being able to communicate in a way that allows that information to pass back and forth is just really critical.
So we are at 1:12.
Okay, wow, okay.
Yeah, we wanted to give everybody about 5-minute warning, but I also wanted to, because I think you're providing a lot of really great information and really appreciate you coming. I wanted to remind everyone to fill out their post-session feedback if you can, please. It's really effective for our funding. And our next didactic will be on August 18th, and the topic will be psychotropic medication. And we encourage all of our NMFAP practitioners to sign up to present a case or issue at one of our upcoming problem-solving issue processing sessions. The case does not have to have anything to do with what that topic is, but it will help get us all of our brains together to help work on something and brainstorm.
So Catherine,
I'm sorry?
I'm sorry, Catherine, there were two topics that I wanted to cover, which I'm not going to be able to cover now, but I think could actually be taken up with the ICWA workers when you have a meeting with them. The first is having a conversation around traditional and cultural rites of passage for kids who are in the department's legal custody. There are certain markers and events that happen in young Native kids' life that should be respected, and having them share those events with you or when they might be happening for their tribe might be a good conversation to have. And then the second one is having them give you some information about how to maintain a child's cultural connections. I wanted to talk about those two things as part of working with Native families, but it might be really good coming from them as the actual resources for the case.
Perfect, thank you.
Thank you, thank you.
Yes, and I would really love that information, Catherine Begaye, if we can somehow get that. I'll send you an email, I guess.
Send an email and I'll get it to you before the end of the day.
Okay, thank you.
Thank you.
And then if anybody wants to present a case for case processing, you can submit that to Jen at eckonmfap@gmail.com. And I think we are done for the day. Thank you so much, Catherine. So much great information.
Yeah, absolutely. Thank you very much. Bye.